Thank you. Good morning. Let's try it again. Thank you. Good morning.
Good morning.
That's better. Let's wake up here. Caleb Sears. Caleb was 6 years old when he died from anesthesiologist. Died from anesthesia, sedation, from a dentist in California. There was no anesthesiologist in the room. Since then, the Sears family has been actively lobbying the California legislature to enact legislation that many pediatricians say would prevent other California children from dying the same way. Their goal is to enact a law to require 2 highly trained professionals instead of 1 to tend to children under 7 who receive anesthesia in a dentist's office. Last year at this time, after 2 years of advocacy, research, heart-wrenching public testimony, the state Senate refused to vote for the bill. It is apparently scheduled to come up for hearings again about this time this year. At the time, last fall, saying that moving ahead with a diluted version would do incredible harm to the effort, the politicians who had been pushing for the legislation opted to shelve the bill at that time. Caleb died because he stopped breathing. After his death, the couple learned that oral surgeons are the only medical professionals allowed to both administer and operate on the procedure outside of a hospital setting. So I am not including emergency room physicians in that group. And there is a difference with emergency room physicians because they are in an emergency room where there are other professionals who are available because you design for the emergency. And the emergency is that the child stops breathing. And you need to have a way to have an interlock guard, a pedal system, something to deal with that emergency if the person that has the emergency before them doesn't react properly. In the Caleb Sears matter, a pediatrician and a Harvard anesthesiologist professor, Dr. Cohen, testified in favor of the bill and likened the concept to commercial planes where a pilot and a co-pilot are equipped to handle emergencies. And if the dentist performing the surgery doesn't have a highly trained co-pilot, there is no one there that can help rescue the child. The California chapter of the American Academy of Pediatrics backed the bill. A study by the State Dental Board, prompted by a bill that the Sears family had lobbied for, also recommended the change. But there was a strong lobby against the bill, and it was weakened by allowing lower-level technicians to assist dentists in sedating young patients. The Sears family proposed tougher amendments that a second provider, another dentist, an anesthesiologist, a highly educated nurse, a nurse anesthetist, be used, which they hoped that the panel would approve. So the California Senate approved a bill backed by the dentists and the oral surgeons lobbying groups to study the cost and safety effects of implementing the tough standards that the Sears family sought. The assistants permitted under the bill that came out of the Senate would only need to have a high school diploma plus several hours of emergency training. There were 2 assistants with high school educations during Caleb's surgery. An investigation by the State Dental Board found that Caleb's dentist made several mistakes in trying to rescue Caleb after the boy stopped breathing and that he waited too long to call 911. The state revoked his permit to administer anesthesia and put his license on probation for 5 years. He no longer administers anesthesia. If surgery requires sedation, he hires an anesthesiologist. And of course, the Senate bill, even if it were to pass, would have to then go back to the House. The House would have to approve that version, and the governor would have to sign it. That's the way our government works. Maybe somebody ought to send a memo to Washington to let them know. So that brings us to informed consent. Informed consent is not the form. It is not the signature. It is not the meeting between a secretary or a nurse or an intern or a resident. It is a communication between a physician and a patient, whereby there's authorization, permission given to perform the procedure. All the other stuff is documentation. So since we last met, I had surgery. I had already been given medications to sedate me. I was on the table, ready to go in, and I didn't have my bifocals on. And a nurse hands me some form under my chin and says, "Sign here." And of course I did. That was my informed consent. No, you'll know, those of you who know this will know where I was. At the first hospital in the United States, in Philadelphia. That's how they handled informed consent. For both ethical reasons, for which there are no standards other than those that you believe in, and legal reasons, patients have to be given enough information so they really understand what they're getting into before they agree to a major treatment. And it also must be documented in writing to meet the requirements of the law. But that's not what it is. And this process of a patient-physician communication involves much more than just getting the patient to sign that form. It was 1914 when a physician removed a tumor from the abdomen of a patient who could set it only to a diagnostic procedure that the concept of informed consent came into the law in New York. Judge's language is, it's the fundamental right of the patient to decide. Isn't this interesting language? It's the fundamental right of the patient to decide what is being done with his or her body. 1914. And the term informed consent really didn't come into vogue until 1950s, and it was from a medical malpractice case, and it was language that was used by the plaintiff's lawyer and then adopted by the court. And all 50 states now do have some level of informed consent. And the failure to do so properly leaves the physician or the dentist or the provider liable for negligence or battery, in other words, civil damages. And there are exceptions made for emergencies. There's exceptions for physical incapacity or mental incapacity. So I want to go back to what this question was, and I kind of like to end on this note, which is, what is the reasonable physician? And who is this reasonable patient? And doesn't that really leave a lot of room for interpretation? And because of that, at the end of the day, you are going to have to use your judgment. And you and the institutions and your fellow providers are going to have to work at improving it. Because what does all this that I'm presenting to you teach us? It teaches us that nobody's getting what you're telling them. They don't get it. You have to figure out a better way to deliver this information. You really need to figure out a way to work together in California. Your anesthesiology groups and your dental groups need to work together to figure out how to deliver anesthesia in the riskiest cases in the best way that is possible. Because do you really want to spend all that money with lobbyists and lawyers to let them figure it out for you? But by getting together, you could resolve it, which I guess brings us back to Starbucks. Because the lesson of Starbucks was to get ahead of solving a problem, to get people who had a major dispute, which could have led to riots in the city of Philadelphia, and get them talking immediately and let the public know that they were talking, so that we could solve a problem in a peaceful and intelligent way and move forward. And I know that the kind of people in this room could do that if they want to. And I think you do. Thank you.